Case 1. Nicholas James Firkus. On the morning of April 25, 2010, Nicholas Firkus called 911 from the home he shared with his wife, Heidi, in St. Paul. Firkus spoke quietly. He said someone was breaking into the house and that he had armed himself with a shotgun. While the dispatcher listened, a confrontation appeared to unfold. Heidi could be heard reacting. Then a gunshot sounded. When police arrived, they found Heidi dead. Nicholas had a gunshot wound to his leg. He told officers that an intruder had entered through the front door, taken hold of the shotgun, and struggled with him. According to Nicholas, the weapon discharged during that struggle, killing Heidi and injuring him. The story immediately depended on one essential claim. An unknown man had forced his way inside, but the front door did not support it. Investigators found no clear sign that the door had been broken open. Its locking mechanism remained functional, and the physical condition of the entrance did not match the violent entry Nicholas described. There was another problem. No useful evidence of an intruder was found in the house. Police did not identify an unknown fingerprint, blood sample, or discarded object that established a stranger had been there. At first, however, prosecutors did not believe they had enough evidence to charge Nicholas. The case remained open for years. As detectives continued reviewing the couple's circumstances, they learned that the Firkus household was facing a serious financial crisis. The home had entered foreclosure proceedings, and an eviction was approaching. Prosecutors later argued that Heidi did not fully understand how close they were to losing the property. Nicholas had controlled much of the financial information and had allowed the situation to deteriorate without telling her the complete truth. The timing became important. Heidi died shortly before the couple was expected to leave the home. Investigators also returned to the emergency call. Nicholas had already armed himself before the supposed intruder entered. He described a struggle in a narrow space. Yet the physical evidence did not demonstrate that a stranger had forced the door or fought him for the gun. The prosecution's position was that there had been no intruder. Nicholas had killed Heidi, wounded himself, and used the call to create the sound of an emergency unfolding in real time. The defense maintained that the home invasion was genuine. His attorneys argued that an unknown man had entered, that Nicholas had tried to protect his wife, and that the state's case was circumstantial. More than 12 years after Heidi's death, Nicholas was arrested and charged with second-degree intentional murder. His trial began in Ramsey County District Court in Minnesota's 2nd Judicial District in January 2023. Prosecutors presented the emergency recording, the condition of the door, the foreclosure records, and expert testimony concerning the shotgun. They argued that Nicholas had staged a home invasion because he was facing the loss of the house and the exposure of the financial situation he had concealed. The defense emphasized the lack of a confession and the absence of a direct eyewitness to the shooting. In February 2023, the jury found Nicholas Firkus guilty of second-degree intentional murder. He was sentenced in April to life imprisonment with the possibility of release after serving the minimum period required by Minnesota law. Firkus continued to deny killing Heidi. He appealed, challenging parts of the evidence and the prosecution's case. The Minnesota Supreme Court upheld his conviction. As of 2026, Nicholas Firkus remains in the custody of the Minnesota Department of Corrections under his life sentence. The call had presented what sounded like a crime in progress, but the house behind that call showed no confirmed intruder. In Connecticut, the next caller created an even more detailed story. This time, a small device worn on the victim's wrist would help dismantle it. Case 2. Richard Dabate. Shortly after 10 o'clock on the morning of December 23, 2015, Richard Dabate activated the panic alarm inside his home in Ellington, Connecticut. When emergency personnel reached the property, Dabate appeared injured and restrained. His wife, Connie, was dead inside the house. Richard told police that a large man wearing camouflage had entered after Connie returned from an exercise class. He claimed the intruder attacked her, restrained him with zip ties, and injured him with a knife or box cutter. According to Richard, he eventually fought back, burned the attacker with a torch, and escaped long enough to activate the alarm. It was an elaborate account filled with specific actions that gave investigators numerous details they could compare with the house and its electronic records. The first difficulties appeared at the supposed entry point. Police questioned whether the disturbance around the home genuinely showed that an intruder had forced his way inside. Richard's restraints also raised suspicion. Investigators believe the zip ties had not been applied in the manner expected after a violent struggle. His injuries were comparatively limited and appeared consistent with being self-inflicted. Then detectives examined the devices inside the home. The alarm system recorded when doors opened and when the system was activated. Computers and mobile phones preserved additional activity. Those records did not align cleanly with the sequence Richard had provided. The most widely reported contradiction came from Connie's Fitbit. Richard's version placed her death earlier in the morning, but data from the fitness tracker showed movement for a later period. Her Facebook account and other electronic evidence also recorded activity that conflicted with his timeline. Investigators then uncovered a motive that had not been mentioned in the emergency account. Richard had been involved in a long-term relationship with another woman. She was pregnant, and prosecutors said Richard had promised that he would leave Connie and begin a life with her. The situation was approaching a point where the two relationships could no longer remain separate. Prosecutors argued that Richard killed Connie to remove her from his life, then staged the house to resemble a violent home invasion. They said he restrained himself, created superficial injuries, and invented the camouflaged attacker. The defense maintained that Richard's account was true and challenged the reliability and interpretation of the electronic evidence. His attorneys also criticized parts of the investigation and argued that the state had turned uncertain data into a murder narrative. Richard was arrested in April 2017. He was charged with murder, tampering with physical evidence, and making a false statement. After delays that included the COVID-era interruption of court proceedings, his trial began in Connecticut Superior Court for the Judicial District of Tolland in April 2022. The prosecution called more than 100 witnesses and introduced hundreds of exhibits. Jurors heard about the affair, the pregnancy, the home alarm records, the computer activity, the mobile phone evidence, and Connie's Fitbit. The case did not depend on the fitness tracker alone. It became one piece of a larger digital record that prosecutors said demonstrated that Richard's emergency account could not be true. Richard testified in his own defense. He continued to blame an unknown intruder. The jury rejected that explanation and convicted him on all counts. In August 2022, Richard Dabate was sentenced to 65 years in prison. He appealed to the Connecticut Supreme Court. The court later found that the prosecutor had committed several improprieties during the trial, but unanimously concluded that those incidents had not deprived Dabate of a fair proceeding given the strength of the overall evidence. His conviction was upheld in March 2025. As of 2026, he remains incarcerated under the authority of the Connecticut Department of Correction. Richard's story failed because nearly every modern device in the house preserved part of the morning. Years earlier in Illinois, another caller had no Fitbit or home alarm to worry about. His problem was the arrangement of two people inside his house, and a woman who eventually told police what he had said before they died. Case 3. Sarah Boone. On the morning of February 24, 2020, Sarah Boone called 911 from an apartment near Winter Park, Florida. She told the dispatcher that her boyfriend, 42-year-old Jorge Torres Jr., was not breathing. Boone said she had found him inside a suitcase in the apartment. She told the dispatcher that blood was coming from his mouth and attempted to follow instructions to perform CPR. When deputies arrived, Boone gave them an explanation that initially sounded like an accident following a night of drinking. She said she and Jorge had been playing hide-and-seek. According to Boone, they thought it would be funny to see whether Jorge could fit inside a large suitcase. She said he climbed involuntarily, and she zipped it closed. Boone claimed she later went upstairs and fell asleep, forgetting that Jorge was still inside. When she woke the following morning, she said she remembered the suitcase, went downstairs and discovered that he was unresponsive. But even during her first conversations with police, parts of the account created questions. Boone insisted repeatedly that she had not intended for anything to happen. She described the incident as accidental and repeatedly used the word unintentional. Investigators then obtained a search warrant for her mobile phone. What they found changed the case. 2 videos had been recorded while Jorge was still inside the suitcase. In the recordings, The suitcase could be seen moving as Jorge attempted to get out. He repeatedly told Boone that he could not breathe and asked her to release him. Boone did not appear surprised that he was trapped. Instead, she spoke to him about earlier problems in their relationship. Prosecutors later argued that the recordings showed she was punishing him rather than participating in a harmless game. The videos directly contradicted the impression Boone had given the dispatcher and responding deputies. She had said that she went upstairs and accidentally forgot about him. But her phone showed that she had remained near the suitcase, listened to him request help, and recorded the situation. During a police interrogation, detectives placed a laptop in front of Boone and played the videos. Boone initially appeared not to remember making them. As she watched, she continued saying that she had not intended to kill Jorge. She attempted to explain that both of them had been drinking and that she believed he could escape from the suitcase. Detectives challenged that explanation. The suitcase had been zipped closed. Jorge was smaller than Boone, but investigators said he could not release himself from inside. The recordings also captured Boone's awareness that he was struggling. That was the central contradiction in the case. Boone's emergency call presented the death as an unexpected accident she discovered the following morning. Her phone showed that she had watched and recorded Jorge while he remained trapped. Boone was arrested on February 25, 2020, and charged with second-degree murder. The case took more than 4 years to reach trial. During that period, Boone was represented by several court-appointed lawyers. Multiple attorneys withdrew after reporting serious breakdowns in the attorney-client relationship. At one stage, the judge ruled that Boone had forfeited her right to another court-appointed attorney because of her conduct toward previous counsel. She briefly prepared to represent herself before private attorneys agreed to take the case shortly before trial. Before the trial began, prosecutors offered Boone an agreement under which she could plead to manslaughter and receive a sentence of 15 years. She rejected the offer. Her trial began in October 2024 in the Circuit Court of the 9th Judicial Circuit in and for Orange County, Florida. The prosecution's case centered on Boone's emergency call, her statements to deputies, the police interrogation, and the videos recovered from her phone. Prosecutors argued that Boone intentionally left Jorge confined in the suitcase as punishment following conflict in their relationship. They did not have to prove that she had planned the killing in advance. For second-degree murder, the state argued that her actions demonstrated a disregard for human life. Boone's attorneys presented a different explanation. They argued that she had experienced repeated domestic abuse during her relationship with Jorge and that her actions should be considered within that history. A defense expert testified about battered person syndrome. Boone also testified. She told jurors that she had feared Jorge and claimed that she kept him inside the suitcase because she believed he might attack her if released. That testimony differed from her original description of the incident as a harmless game followed by an accidental night of sleep. Prosecutors highlighted the change. On the morning of the emergency call, Boone had not told the dispatcher or the first officers that she had deliberately kept Jorge confined because she feared him. That explanation emerged years later at trial. The jury also watched the mobile phone recordings. Those videos became the most important evidence because jurors could hear Boone and Jorge without relying entirely on either side's interpretation. The defense argued that the recordings reflected the history of conflict and abuse between them. Prosecutors argued that they demonstrated control, punishment, and Boone's refusal to help despite knowing Jorge could not breathe. On October 25, 2024, the jury found Sarah Boone guilty of second-degree murder. The verdict came after less than 2 hours of deliberation. At sentencing on December 2, Boone addressed the court and continued discussing the relationship and the abuse she alleged she had experienced. Members of Jorge's family described the effect of his death on their lives. Circuit Judge Michael Kranick sentenced Boone to life in the Florida Department of Corrections. Her request for a new trial was denied before sentencing. Boone was later transferred from the Orange County Jail into state custody. Florida correctional records identify her under offender number U72509. As of July 2026, Sarah Boone remains imprisoned under her life sentence. Her direct appeal is active in Florida's 6th District Court of Appeal, where filings and extensions have continued into 2026. Her call to emergency services initially described a night that had ended in an accidental discovery. But the videos on her own phone showed that she had been present, recording, while Jorge asked to be released. The call did not create the strongest evidence against Sarah Boone. It preserved the first version of her story before detectives showed her what her phone had already recorded. If you're finding these cases informative, consider subscribing to Quiet Room Cases. We publish carefully researched true crime documentaries focused on investigations, evidence, and the pursuit of answers. Case 4. Michele Marie Williams. In the early hours of October 13, 2011, Michele Williams contacted authorities from the home she shared with her husband, Gregory Williams, in Keller, Texas. Gregory had been shot in the head while in bed. Michele initially said that a man dressed in black had entered the house. She claimed the intruder struck her and shot Gregory before escaping. Police examined the property, but the reported break-in did not look convincing. The house did not contain the clear signs of violent entry investigators expected. Michele's account of the intruder and her own encounter with him also began to create questions. During a lengthy police interview, her story changed. Michele abandoned the intruder explanation and said Gregory had taken his own life. She claimed she had altered the scene because she did not want their daughter to know that her father had died by suicide. That explanation required investigators to believe that she had cleaned or repositioned evidence and invented an attacker solely to protect the child. Medical and firearm evidence created a different conclusion. The medical examiners who reviewed Gregory's death classified it as a homicide. Firearm testimony indicated that the weapon had been fired from a distance inconsistent with the suicide scenario Michele described. Investigators also examined Gregory's life insurance coverage. Michele was the beneficiary of policies worth hundreds of thousands of dollars. Prosecutors presented the insurance money as part of the financial motive behind the killing. Michele was arrested approximately 3 months after Gregory's death and charged with murder and tampering with evidence. Before trial, she entered an agreement that would have resolved the case with a shorter sentence on reduced charges. She later withdrew from that arrangement, choosing to proceed before a jury. Her public statements then became another difficulty. Michele had participated in a television interview in which she promoted versions of events that could be measured against her earlier police statements. The shifting explanations, intruder, suicide, and denial of responsibility allowed prosecutors to show jurors that her account had repeatedly changed. The trial was held in the 396th District Court of Tarrant County, Texas, in September 2014. Prosecutors argued that Michele shot Gregory, altered the room, and created the intruder story because she expected to benefit financially. The defense returned to the suicide explanation. Her attorneys argued that Michele had panicked after discovering Gregory and had made poor decisions while trying to shield their daughter. The state's medical witnesses rejected that account. The jury was also shown evidence of Michele's changing statements and the steps taken to alter the scene. Michele was convicted of murder and tampering with physical evidence. The jury sentenced her to 60 years in prison for murder and 10 years for tampering. The sentences were ordered to run concurrently. Her convictions were affirmed on appeal. The Texas Appellate Court reviewed the medical, firearm, insurance, and circumstantial evidence and left the judgment in place. As of 2026, Michele Williams remains in the custody of the Texas Department of Criminal Justice under her 60-year sentence. The emergency call had introduced an unknown attacker. Within hours, Michele replaced that attacker with suicide. At trial, the state argued that neither version could survive the evidence. The next Texas case also began with an intruder report. But unlike Michele's changing account, the caller maintained her innocence for decades. Case 5. Darlie Routier. At 2:31 on the morning of June 6, 1996, Darlie Routier called 911 from her home in Rowlett, Texas. She told the dispatcher that a man had entered the house and attacked her and her 2 young sons, 6-year-old Devin and 5-year-old Damon. Police arrived within minutes. Darlie had wounds to her neck and arm. The 2 boys had been killed. A kitchen knife lay inside the house, and a cut screen in the garage appeared to provide a possible entry point. Darlie said she had fallen asleep downstairs with the children. She reported waking to find an unknown man in the room. According to her account, she followed him as he fled and then discovered what had happened. The emergency recording captured Darlie speaking with the dispatcher while police and paramedics responded. Prosecutors later used portions of that call to argue that her attention and statements were inconsistent with the emergency, as she described it. The defense strongly disputed attempts to interpret her behavior, arguing that people respond unpredictably during trauma. The case was not based on the call alone. Investigators examined the cut screen, the broken glass, blood evidence, and the location of a sock recovered away from the house. Prosecutors argued that the screen had been cut from inside, using a knife associated with the residence. They also maintained that items in the room appeared disturbed selectively rather than during a genuine burglary. Nothing valuable had been taken. Investigators believed Darlie's wounds were self-inflicted or created as part of the staging. The defense presented medical testimony and photographs to argue that her injuries were more serious than the prosecution acknowledged. The sock became one of the case's most debated objects. It contained blood associated with the children and was discovered in an alley away from the home. The prosecution argued that Darlie had enough time to place it there and return. The defense said the sock supported the presence of a fleeing intruder and made the state's proposed sequence difficult. Prosecutors presented financial pressure within the Routier household as a possible motive. They argued that Darlie felt overwhelmed by debt and her circumstances. The defense rejected that explanation and maintained that no credible motive had been established for a mother to kill her children. Darlie was charged with capital murder. Because of extensive publicity in Dallas County, the trial was moved to Kerr County and conducted in the 202nd District Court. The prosecution focused on blood evidence, the allegedly staged room, Darlie's injuries, and her statements during and after the call. The defense argued that police had settled on Darlie too quickly, failed to pursue an intruder adequately, and interpreted disputed forensic evidence as certainty. In February 1997, the jury convicted Darlie of the capital murder of Damon. She was sentenced to death. She has maintained her innocence ever since. Her conviction was upheld on direct appeal, but litigation continued over DNA testing of evidence collected from the house. Courts authorized additional testing as technology developed, and her attorneys have continued challenging the conviction. The opposing positions remain sharply divided. The state regards the physical evidence as proof that the scene was staged. Darlie's defense maintains that unidentified evidence and the sock support an intruder. As of 2026, Darlie Routier remains on Texas death row. Texas Department of Criminal Justice records identify her as an active death row prisoner. No execution date has been publicly confirmed. Her case remains controversial, but its legal status is clear. The conviction and death sentence remain in force unless a court grants further relief. In North Carolina, the final caller also maintained that an accident, not a crime, had occurred. That case ended with a conviction, a new trial order, and a plea that allowed him to continue asserting his innocence. Case 6. Michael Peterson. At 2:40 in the morning on December 9, 2001, Michael Peterson called 911 from his home in Durham, North Carolina. He said his wife, Kathleen, had fallen down the stairs. During the first call, Michael reported that Kathleen was still breathing. He called again several minutes later and said she was no longer breathing. When emergency personnel entered the house, they found Kathleen at the bottom of a narrow back staircase. The amount and distribution of blood immediately caused concern. Investigators questioned whether an ordinary fall could explain the scene. Michael said he and Kathleen had spent the evening outside near the swimming pool. According to him, she went inside first. He remained outside before eventually entering the house and finding her. That account left an uncertain period between the time Kathleen entered and the moment Michael called for help. The medical examiner classified the death as homicide. Prosecutors argued that Kathleen had been struck during an assault. Michael denied attacking her. His defense maintained that she had fallen after consuming alcohol and medication, striking her head repeatedly on the staircase or surrounding surfaces. The state searched Michael's computer and discovered evidence concerning relationships he had concealed from Kathleen. Prosecutors argued that Kathleen discovered information about Michael's private life and that an argument followed. The defense disputed that theory and maintained that the couple had a strong and accepting marriage. Investigators also focused on a fireplace tool called a blowpoke that relatives initially believed was missing. The prosecution suggested it could have been used as a weapon, although it was later found and no conclusive evidence established it as the object responsible for Kathleen's injuries. The case went to trial in Durham County Superior Court in 2003. Prosecutors presented the bloodstain testimony, the medical examiner's findings, Michael's private communications, and evidence concerning an earlier death in Germany involving family friend Elizabeth Ratliff, who had also been found near a staircase. Michael was never charged in Ratliff's death. The defense argued that introducing it created unfair prejudice and distracted from what happened to Kathleen. The defense called experts who disputed the state's blood evidence and argued that a fall could explain the injuries. After a lengthy trial, the jury convicted Michael Peterson of first-degree murder. He was sentenced to life imprisonment without parole. Michael appealed, but the conviction was initially upheld. Years later, the reliability of a state bloodstain analyst who had testified against him came under serious scrutiny. A judge concluded that the analyst had provided materially misleading testimony and granted Michael a new trial in December 2011. Michael was released while prosecutors considered trying the case again. By 2017, both sides faced uncertainty. The state had lost confidence in part of its original forensic presentation, while prosecutors still believed sufficient evidence remained to pursue a conviction. Michael entered an Alford plea to voluntary manslaughter in Durham County Superior Court. Under an Alford plea, a defendant does not personally admit committing the crime but accepts a conviction because the prosecution possesses evidence that could likely persuade a jury. He was sentenced to a maximum of 86 months and received credit for the years he had already served. He therefore left court without returning to prison. Michael Peterson continues to deny killing Kathleen. His legal status is sometimes described incorrectly. His original first-degree murder conviction was vacated and no longer stands. His final conviction is for voluntary manslaughter under the Alford plea. As of 2026, he is no longer incarcerated and has completed the sentence imposed in that case. His emergency call did not settle whether Kathleen had fallen. It created the first recorded version of an explanation that investigators, medical experts, lawyers, and courts would debate for more than 15 years. Emergency calls are designed to bring assistance into a moment of crisis, but they also preserve time, language, and decisions. A caller may direct officers toward an intruder, an accident, or an act of self-defense. Investigators must then determine whether the house, the devices, the witnesses, and the physical evidence support that explanation. In these cases, accountability did not come from a caller sounding calm, frightened, or emotional. It came from comparing what was said with what could be independently proved. Thank you for spending time with Quiet Room Cases. If you found this documentary informative, please like, comment, and subscribe. We'll see you in the next case.